All right, so again, you're Brian McQuaid,
Yes, ma'am.
and get it pulled up again.
June second. Right, June second, I believe, how are you, June?
Now it's spinning.
I'll have seven files.
Okay, so Mr. McQuaid, in cause number 26, DCCR 0402, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 8th of 2026. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Macon that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would be probated. You'd be on probation for 10 years. You would do 30 days upfront time and follow all of the rules and conditions of probation. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get it set for trial. Is there any reason, Mr. Coleman, to believe that offer would change?
I got it.
So I do want to make sure you understand, Mr. McWade, that once your case is on my trial docket, I don't accept this plea agreement again, unless there's some new information that the attorneys don't have or know about right now. Otherwise, if you change your mind and you want to enter a plea of guilty later, it would be either open to the court or to something other than what's been offered today. Do you understand?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Macon will begin preparation for trial.
Thank you.
Good morning, ma'am. Are you Sasha Swofford? Just stand right there. Are you Sasha Swofford? Answer yes or no, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Swofford, in cause number 25, DCCR 1493, the state is elected to proceed on count one only. It alleges that you committed the state jail felony offense of theft of material, aluminum, copper, bronze, or brass, and that's from June 30th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Swofford is not
No,
competent?
Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of material, sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff. Sorry, you Roger Anders. This is 25 DCCR 0388. Mr. Anders is charged with aggravated assault with a deadly weapon. And what is the announcement?
Ready to
State's
just
ready.
this on the trial doc.
Okay,
State's
for
ready, Judge. We'd ask that you call a name, please.
today.
Yes, ma'am.
What is that name?
The sudden surprise, Stevens, Judge.
The Sudden Surprise Stevens. But Ms. Stevens has been here with us before.
So I've been,
Okay.
It's not one of those you forget.
Judge, we'd also ask if she is here that you admonish her about the consequences. She's under subpoena, she's already. but the consequences of not. We've also subpoenaed her to bring the 2 juvenile witnesses with her as well. Yes, Steve.
Miss,
Good call.
it's her, it's opposite.
You come, Dave.
Y'all, if you'll, move around this way, please, sir. Good morning, ma'am.
Good morning.
You are LaSudden, Stevens?
Yes, ma'am.
And Ms. Stevens, I just wanted to bring you here. You are under subpoena for a trial next week regarding Mr. Anders. And I just want to admonish you that once you are under subpoena, you are required by law to show up when you are told to show up. Also, if there are any juveniles that are part of this that are also under subpoena, that you are required to bring them here if they're in your care. Do you understand?
Yes, ma'am.
Okay, if you don't, then there could be potential consequences and nobody wants that. I'm not trying to threaten you. I just want to make sure you understand the importance of it so that there's no issues with you getting any kind of trouble, okay?
Yes, ma'am.
All right, you can step back out.
Thank you, Judge.
All right, and so looks like there was a previous plea rejection in this case of a 10-year term, correct?
Yes, ma'am.
Any changes in that offer or negotiations that I need to be aware of?
No.
All right, so I will number the case as soon as docket is over today. All right, you can go back with the bailiff. Good morning, sir. You're Jesse Griffin. And this is cause number 25 DCCR 1397. Mr. Griffin is charged with aggravated assault with a deadly weapon. I'm going to take judicial notice of the court's file. Looks like Mr. Griffin was evaluated for competency to stand trial. Received that report from Dr. Papon dated April 15th of 2026 with the finding that Mr. Griffin is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then I am going to find at this time Mr. Griffin is competent to stand trial. And what is the announcement?
No.
Yes.
Your Honor, he still would like to proceed to a jury trial.
All right, so it looks like there was a plea bargain rejection in January where the offer was for 8 years. Is there any change in that offer or negotiations?
No, Your Honor.
So, Mr. Griffin, you still want to reject that and have your case set for trial?
Yes, ma'am.
All right, we'll get you moved to the trial docket. Ms. Coffin will begin preparation for trial. I do want to make sure you understand that after today, I will not accept this plea agreement unless some new information that comes to light that the attorneys don't know. If you change your mind later, want to enter a plea of guilty, it could be open to the court or to some different plea agreement, but not this. You understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Your Honor.
Yes, ma'am. Good morning, sir. You're Hayden Burkhalter?
Yes, ma'am.
This is 26 DCCR 0324. Mr. Burkhalter was previously in court and entered a plea of guilty to aggravated assault with a deadly weapon. I received that pre-sentence report. Has everyone had an opportunity to review that report?
Have to.
Yes, Your Honor, I have.
Any additions or corrections?
Not from the state, Your Honor.
Nothing finished.
All right, Mr. Burkhalter, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings and place you on probation for 10 years. You are ordered to pay the $500 fine and to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case is actually dismissed. You'll never have that conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and sent to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. As soon as the probation will talk to you probably today, but as soon as you're released from ISF, first thing you do, go to probation, get everything started, okay? Good luck to you, sir. You go back to the bailiff. Hey, ma'am, are you Christina Rodriguez? And so this is cause number 17-27256, and Ms. Rodriguez is on probation, and there's been a motion filed Ms. Rodriguez, before we do anything else on your case, just based on some information that I have, I'm going to reset your case. We're going to have a doctor do an evaluation just to make sure we have competency, and then we'll get you back in court within just a few weeks, okay? So if they come in person or if they go over the Zoom thing that they have at the jail, just cooperate and go through that appointment with them and their questions, and then we'll see where we get from there, okay? This is to make sure that you understand everything and that you are competent to stand trial. Okay? All right, you can go back with the bailiff. Good morning. You're Derek Corbin,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
He does.
And I'm also going to take judicial notice of the court's file. I know there was back in January an examination for competency. Mr. Corbin was found competent to stand trial. We've already gone through all of that. Anything changed with regard to competency?
No, Judge. Not that I'm aware of.
Right. Then Mr. Corbin, in cause number 25 DCCR 1659, you're charged with the second-degree felony offense of robbery, and that's from October 25th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Corbin, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right. Good luck to you, sir. You can go back with the bailiff. Are you Robert Eaglin?
Yes.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with a family member, and this is set for trial to begin with jury selection next Monday. What is the announcement?
Well, Judge, we're ready for this.
Okay.
Being ready for trial. We did get a new offer from the state that included a reduction that would amount to a time served sentence from Mr. England, and the state would be willing to accept a no contest plea as well. And Mr. England, to my understanding, is rejecting that and still wants to go forward.
Judge, if I may, just for the court's knowledge, fill that in a little bit. Obviously, it's up to the court to accept that. The state would be willing to ask the court to consider a no contest based on the evidence in this case and proffer to the court evidence of the offense itself. This case was set for trial back several months ago. It was reset on part of the state. We are ready for trial. I have secured arrangements to have the complainant, Ms. Hernandez, here. I have offered Mr. Eaglin, based on the nature of the entirety of the case. If you'll recall, it was first indicted in CDC. We were unable to locate her. He was in custody for quite some time. She then surfaced. It was re-indicted. She has been cooperative all along the way. I just want Mr. Eaglin to know, from the state's perspective, this offer is not made based on lack of a witness, lack of having officers. My investigators have worked up the case already, and we've met with witnesses. We'll be ready to proceed. It is based on judicial economy, and out of fairness to him, I feel like the time that he served would be sufficient for the case as indicted with a no no contest plea, and I want him to be fully apprised by the court, if you don't mind, before we go through all those hoops of bringing her here again, that he understands what it is that he's rejecting, and that I will intend to proceed, obviously, with the deadly weapon finding and the full indictment, which enhances his punishment.
So what is that new offer?
5 years credit for time served. However, that would be worded on the judgment. I believe he has it, Your Honor, or in alternative, a 10-year probated over 10-year probation, both of those to count one of the indictment.
So, Mr. Eaglin, you've heard all that, and I'm sure Mr. Lewis has talked to you about that. And it looks like, obviously there was a much larger offer, that you rejected some time ago. Today, I'll number the cases for trial. Your case is obviously one of my older ones. I'm not sure if it'll be number 1 or number 2, but it's going to be right up there. And probably going to trial next week. I want to make sure you understand, what the offer is now, which would be either a 5-year term where you would get credit for any time that you've served, or a 10-year probation. You have every right, again, to reject that. We can go to trial next week. I do want to make sure you understand that after today, once I number those trials, I don't typically accept plea agreements unless there's something very different that comes up or there's some issues. Do you understand?
Yes.
And you want to move forward with your trial.
Yes.
And I do want to make sure, based on the indictment and your history, that you are a first-degree enhanced. If you are found guilty, which means your minimum punishment would be 15 years. You understand? Okay, then I'll number the case. Mr. Lewis will get that number as soon as docket's over today.
Thank you.
Thank you, Coach.
Responsibility, Judge.
That's good. I appreciate that. No. All right, sir, you're Jaden Simon.
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case, Mr. LeBlanc?
Yes, Your Honor. Y'all, it's helpful. Tell the truth.
Yeah, and can you, well,
I'll tell them when I do.
need 2 of them. If you'll do one for each case, and then you can email that stuff later. You can get it done as soon as we're done.
Yes, sir.
And so, Mr. Simon, in clause number 25 DCCR 1760, you're charged with a first-degree felony offense of aggravated robbery. I'm sorry. Oh, I pulled up the wrong one. Let me start with this one. In cause number 25 DCCR 0918, you're charged with a second-degree felony offense of robbery. And that's from June 12th of 2025. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Answer out loud for the court reporter.
Yes, ma'am. I apologize.
That's okay. And then in clause number 25 DCCR 1760, you're charged in that case with the first-degree felony offense of aggravated robbery from October 10th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Simon is not competent?
None of them were, Your Honor.
All right, sir, I'm going to find in each case that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25 DCCR 1760, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. You'll receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0918, also find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you in each case the trial court certifications that shows that these were agreements that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. LeBlanc. All right.
Yes, ma'am.
Good luck to you, sir.
I got a question.
Yes, sir.
I was trying to see, will I be able to get 35% I forgot what it was called, 35% on like,
So whatever happens in prison is up to the prison authorities
that's
and
the-
parole. It's up to them. It's not up to me. So if whatever's available, you would get it typically as long as you're doing well. So what you need to do, you're so young. And I know this is a long time, but it'll go by probably quicker than you think. And you're gonna still be young when you get out of prison. There are things you can do in prison to actually better your life, that you can learn a trade so that when you get out, you can have a job. But they're not gonna make you do anything. It's gonna be up to you to search that out, be doing right so that you can take advantage of those opportunities. You don't have to be a career criminal. You can change your life, okay? It's totally up to you, and I hope you do.
yes, ma'am.
All right.
Thank you.
Good luck to you, sir. All right, so we've just got that one left.
Good morning, Your Honor.
Good morning. All right, so are you Calvin Hawkins Jr.?
Yes, ma'am.
And this is 24 DCCR 1160, and Mr. Hawkins is charged with unlawful possession of a firearm by a felon. And what is the announcement?
Your Honor, is it possible to briefly talk with the DA?
Sure, I'll give y'all just a few more minutes if y'all want to visit, and then I'll need an announcement after that. All right, we'll be in short recess. Thank you. Let's see. All right, sir, you're Calvin Hawkins Jr. All right, and let me get you pulled up here real quick. And Miss, is it Bosley or Bosley?
Bosley.
And Miss Bosley, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Judge, there's something before you get started. I think we probably should put on the record, please,
Sure.
if you don't mind. Ms. Bosley's been the discovery's been made available to Ms. Bosley. She, online, she's reviewed it and she's reached out to me with some questions about the existence or the non-existence of some videos in this case. I asked my investigator, Alton Base, to reach out to the sheriff's department about whether or not there are additional videos that exist. And he did so, and he's informed that they do not exist.
Okay.
I think Ms. Bosley can maybe articulate it more as to why she thinks that there should have been, or why she has questions about it. But nevertheless, I suggested to her that, by all means, she could set it for a hearing. She can issue a subpoena for the officers. I certainly will do whatever I need to do to facilitate that if that's what she chose to do.
Yes,
Okay.
Your Honor. In the police report, the officer that pulled over Mr. Calvin stated that she uploaded a body cam footage and dash cam footage, and that was nowhere. And so
Okay,
that was our concern.
sure. But it sounds like whatever they did with it, it's not there now, unfortunately.
Yes, Your Honor. I don't know what happened with it. so-
Okay. All right. Thank y'all for putting that on the record. And, but you want to go forward with the plea today, is that correct?
Yes, ma'am.
And are we going on count one only?
That's correct, Judge. The state would abandon one of those enhancement paragraphs. Or punishment
Both of the,
enhancement paragraphs.
okay. All right. So Mr. Hawkins, in cause number 24 DCCR 1160, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of unlawful possession of a firearm by a felon from January 31st of 2024. And how do you plead to that charge?
No contest.
It's guilty or not guilty? I'm sorry.
Guilty.
Are you pleading guilty freely and voluntarily?
Free.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Bosley? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1, any objection?
No,
It's admitted. Is there any evidence that Mr. Hawkins is not competent?
he's competent, that's my knowledge.
Thank you. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have
story, but the lesson is often the same. Our choices shape our future. Do you think justice was served in this case, or should the outcome have been different? Let us know your thoughts in the comments, and don't forget to like, subscribe, and turn on notifications for more real courtroom stories.